Hello everyone, I'm George from Ireland. So this video on my English Law channel is about human rights in the United Kingdom. So the French claim to have invented human rights, but we could go back to ancient India, Emperor Ashoka, ancient Iran, some sort of notion of human rights. But the French came up with the rights of man and of citizen in 1789. So the expression human rights was hardly ever used until just after the Second World War, in the wake of manifold atrocities perpetrated, well, by all countries actually, but principally by the Third Reich. Anyway, after 1945, people began to think about human rights a great deal, and the expression entered common usage. So in 1948, the United Nations promulgated the Universal Declaration of Human Rights, and various other human rights instruments, such as the International Covenant on Civil and Political Rights, as well as a covenant on economic, social and cultural rights, and so on. So the European Convention on Human Rights was drawn up in 1948, ratified in 1950. The United Kingdom has been part of it since 1953, despite having been part of the drafting process. So the Council of Europe is responsible for the European Convention on Human Rights, not the European Union. All right, the European Union didn't exist when the European Convention on Human Rights was written. For short, we just call it a convention. The European Economic Community did not exist back then, which was the precursor. And I don't think even the European Coal and Steel Community. So there's a common misconception. So the Council of Europe includes almost all countries in Europe at its broadest definition, as in from Iceland to Azerbaijan, right, and from Portugal to Russia, including some fairly tyrannical regimes. So, and the European Court of Human Rights is the one that adjudicates on this, but come to that later. Anyway, so we often talk about civil liberties, as in freedom of expression, habeas corpus, so forth, the right to assemble freely. So these were largely guaranteed by statute and by common law, but the convention rights, as in those which are enshrined in the European Convention on Human Rights, they were domesticated in the United Kingdom by the Human Rights Act 1998, which was in Labour's manifesto. Labour won a thumping victory in 1997, and the Human Rights Act that took effect in the year 2000. And that has changed the relationship between the United Kingdom's courts and the European Court of Human Rights. The European Court of Human Rights sits in Strasbourg. It is not an EU court. I'll say it again. The European Court of Human Rights is not an EU court. But it's very confusing because it's in Strasbourg, which is where the European Parliament meets half the time. The European Union's got the European Court of Justice, which meets at Luxembourg. The European Court of Justice, we're supposed to call it the Court of Justice of the European Union. Ugh, quite a mouthful. We often say ECJ for short. So there have been many controversies arising from the European Convention on Human Rights, ECHR, or the Convention, being part of UK domestic law, and people dispute where the final say ought to be, especially as there's been a recrudescence in terrorism since 9/11, and the Convention hamstrings the government's attempts at counter-terrorism. So in the last few years, a lot of people have said that the HRA, Human Rights Act, ought to be done away with or possibly reformulated. People talk about British Bill of Rights. Of course, the UK's got a Bill of Rights from 1689, but a new one, an extended one. So we're going to look at human rights issues in the UK and the jurisprudence thereof. Anyway, so what are human rights? Well, the UK's got an Equality Human Rights Commission, and it gave the following précis. Human rights are basic rights and freedoms that belong to every person in the world from birth to death, and apply regardless of where you're from, what you believe, or how you choose to live your life. These basic rights are rights based on values like dignity, fairness, equality, respect, and independence. In dignity, I'm not quite sure about. Do I behave in a dignified manner, or an undignified manner, or what? Or I'm feeling indignant. But I think you're not meant to do things which is unwarrantably humiliating for someone. Like we don't tie people up in the stocks. People aren't pilloried as they used to be as a punishment. Okay, so the different kinds of rights. We could divide these into two major categories: civil and political rights, and then there are social and economic rights. So civil and political rights are often called first-generation rights, whereas the economic ones are called second-generation rights, pretty much everyone accepts the first generation rights, at least pays lip service to them. These second generation rights are more contentious. So the first generation rights, civil and political rights, that is, they include your right to life, to freedom of expression, to right to a fair trial, and so on and forth. But the second generation rights, as in social and economic rights, are about the right to education. Is education a right? Do you have a right to healthcare? Do you have a right to food, as you do in Cuba? So now these political and civil rights, they are limitations on what the government can do. So prevent them from abusing you. So you're not to be jailed unless you're found guilty of a crime. You're not to be tortured, and so on. You can't be killed without a very good reason, and you can't be prevented from voicing your opinions, from worshipping as you please. But social economic rights are rather distinct because they would actually mandate the government to do things and not to refrain from doing things. And this obviously involves fiscal decisions. We're going to have to raise tax or borrow more, cut spending in other areas to fund healthcare, education, and all sorts of amenities for people. So some people talk about even a third generation of human rights. These are collective rights, which pertain to communities and not to individuals, often ethnic and religious communities. So let's look at the international aspect to this. So the Second World War catalyzed human rights, and even the word genocide didn't exist till Raphael Lemkin, this American jurist, coined it. So there was no word for deliberately trying to annihilate a group of people based on ethnicity or faith. So there've been lots of human rights instruments trying to prevent horrid abuses. So anyway, European countries said we share this common goal of upholding human rights to prevent evil, not very successfully in some cases. So the United Nations came up with that Universal Declaration of Human Rights, as I said, and it's signed by all sovereign states, I'm pretty sure, including ones which behave absolutely abysmally like North Korea and Saudi Arabia. So it really seems to be just a dead letter. And on the other end of the scale, there are ones who behave fabulously, like, say, Sweden and Denmark, and they almost never mistreat anybody. So there's also the International Bill of Human Rights, and that, including UDHR, has got the International Convention on Economic, Social and Cultural Rights and the International Convention on Civil and Political Rights. There are also two protocols to those which are optional. So if you sign one of those human rights instruments, you don't also have to sign the protocol. So anyway, so the International Covenant on Civil and Political Rights says that the states that party to it have to not discriminate against people on the basis of their race, religion, faith, colour, national origin, political opinion, and so on. It doesn't say sexuality, because this is quite some time ago. So according to this, you would not be prohibited from discriminating against someone on the basis of sexual orientation. And further, the ICCPR says these states have to take whatever steps they can in order to make these rights effective. So no one if someone's deprived of their rights, the state ought to have legal processes by which the person can attain redress. And these can be through the courts, through bureaucracy, through other legislation, things like that. Anyway, so looking at the International Covenant on Economic, Social and Cultural Rights, it says that every country that signs up to it has to do everything it can to, using its economy, using its technology and so on, to make these rights become a reality. And again, no discrimination on the basis of gender, language, ethnicity, faith, your viewpoint, how much money you have, where you're born. But again, it does say and other status, but it doesn't actually mention sexuality either. But this is about to express your culture and to have a minimum standard of living with enough time for rest and relaxation and things like that. Okay, but so it's very dispiriting to see countries sign up to these, and some of them, the regimes just abuse them massively. So there's the Council of Europe, as which I said, came up with the ECHR, and the ECHR took force in 1953. So 47 countries have signed up to it, including very small European countries. So there are only 27 countries in the EU, but there are 47 countries in the Council of Europe. So the Council of Europe is not the European Union. Confusing, the European Union has a European Council, which meets twice a year with the heads of government, i.e. the prime ministers. So the European Council is something within the EU. The Council of Europe is something totally different. People often get muddled between those. So the Council of Europe, it functions through international law, and the European Convention of Rights, the Court of Human Rights, is meant to adjudicate this. So these rights are justiciable. So anyway, it's very confusing. Even major newspapers like the Times have got it wrong sometimes. So it'd be easy if we said the Strasbourg Court, as in European Court of Human Rights, and the Luxembourg Court, as in the European Court of Justice, and it's the latter is an EU court. So there are various institutions pertaining to the European Court of Human Rights. Anyway, so in 1998, Protocol 18 of the Convention took force. So anyway, there's a committee of ministers meets. Really, these are foreign ministers of all the countries of the Council of Europe, 47 of them, and the European Court of Human Rights has got 47 judges, as in one from each member state, and a judge can't hear a case relating to his or her own country. There's also a parliamentary assembly, and so they sent people there as well. The judges are elected by the member states. So these judges, they're meant to be independent. They're not trying to be there acting in furtherance of their national interests. They're meant to be disinterested, just doing justice without fear or favour. All right, so how can things be enforced in the European Court of Human Rights? There's a thing called individual petition, which is allowed under Article 34 of the Convention. So an individual can take action against a state, including his or her own state, if he or she says that his or her rights have been abused. This has been going on in the UK since 1966. Right, so they're interstate applications. One member state can initiate a case against another, and that's done pursuant to Article 33. So it's any high contracting party, that's a member state signed up to it, may refer to the court any alleged breach of provisions of the Convention and the protocols thereto by another high contracting party. So these so-called interstate cases are unusual. There have only been 24 of them ever. So why are they unusual? Because the court has to decide that the case is admissible. Prefer if there's an amicable agreement between the two member states. Anyway, so there's a thing called margin of appreciation, which means you're not sticking to it that strictly. So this is what Fenwick had to say about it in his book on the same. He said the European Court of Human Rights has stated the role of the Convention in protecting human rights as subsidiary to the role of the national legal system, and said that the state is better placed than the international judge to balance individual rights against general societal rights. Strasbourg will operate a restrained view of the balance struck. Right, so your first recourse must be to your national courts. Only having exhausted all remedies there, that court can refer it to the European Court of Human Rights. You can't choose to take it, it's they have to allow it to go ahead. And usually matters are dealt with long before it would get to the Strasbourg Court, European Court of Human Rights. Okay, so there are some rights are absolute and some are qualified. So what absolute rights are the ones in Article 3, which outlaws torture, no matter what the circumstances, even a ticking bomb scenario, and says that inhuman and degrading punishment is never permitted. Article 4 says no slavery, ever. It says compulsory military service, that's different, that's not slavery. It said in an emergency situation, if you had to conscript people to build a dam because of flooding, for instance, that would be permitted. Or let's say in Finland, if you don't do your military service, you have to do some other sort of social service like helping out a nursing home. That's not slavery. You are paid. You're not in slave-like conditions. Okay, there was an Article 3 case, which is Ireland and the United Kingdom, 1978, where the Republic of Ireland, we alleged the United Kingdom had tortured some terrorist suspects in Northern Ireland, I think 6 of them. So the European Court of Human Rights eventually found that there had not been torture, but there had been inhuman and degrading treatment. So Article 3 prohibits a country from deporting someone to a country where he would face a significant chance of torture. There was a well-known case, Chahal and the United Kingdom, 1996. Chahal was an Indian. He was a Sikh, part of the KLF, Khalsa Liberation Force, a terrorist organisation committing acts of violence in India. He fled to the UK, and he couldn't be deported to India because there was a serious chance of being tortured if he was returned. Then there are qualified rights, and most rights in this are qualified, as in limited, as in it depends, and there can be some exceptions. There can be no exception to torture, right to life, and so on. When I say right to life, the army, the police, they are allowed to kill people under circumstances. If it's a combat situation, they can kill that person. There's some other situation, someone who's wielding a knife threat to kill people, the police could shoot that person dead and it'd be completely lawful. But the army and police aren't to kill people unless it's some sort of situation like that. So, what are some of these qualified rights? So sometimes the state has to intervene and restrict individual rights. There's Article 8, the right to privacy, but that's not absolute. They could search your body, they could listen to your phone calls if it was warranted by evidence of a possible crime. And there's Article 10, freedom of expression, but then you have the right to protection from attacks upon your honour. So we can have libel laws. So there are limits to these rights, as what are called qualified. So Article 5, that's the right to liberty, but you can obviously still be sent to prison if you're found guilty of a crime. You can be held on remand there. Article 5 can be suspended under dire circumstances, and you can be interned. So anyway, these rights, they can only be limited or suspended if it's warranted by the situation, and you can't overdo it, only as much as you need to. You can't misuse it as an excuse to effectively abolish these rights. So Article 8 is the right to respect for private and family life, home and correspondence. Okay, so you have the right to get married, to have children. Does this include gay couples? Well, member states usually take the view that it does now, but not all of them do. Gay marriage is not allowed in most of the countries signed up to the convention. And correspondence, as generally speaking, the authorities are not allowed to listen to your phone calls, read your emails, but there are extenuating circumstances where, pursuant to an investigation, they can, if they have a prima facie case that there's some plot to be uncovered. The right to freedom of thought, belief, and religion. But if you said that your religion allows female genital mutilation, tough, you're not allowed to do it. There is a limit. Article 10 is about freedom of expression. As I say, incitement to racial hatred and so on, that's not allowed. Article 11 is freedom of assembly and association. So yeah, you can have protests, but in the United Kingdom, then you have to seek police permission, usually 6 days in advance. And they sometimes say no. They sometimes say you can do it, but not there. Or sometimes say you can do it, but not on that day. Okay, so there are qualified rights. So what is a qualified right? It's a right where the state can intervene and curtail this. But again, and there's a limit on that. They must be proportionate in the manner they're doing this. The second thing about these qualified rights is that any interference by the state must be furthering a legitimate aim, as provided for under Articles 8 to 11. For instance, it must be because they're trying to safeguard the rights of others, they're trying to protect public health, like coronavirus lockdown, they're trying to uphold morals in society, it's a matter of national security, as in somebody's trying to kill people, a matter of public safety if there's flooding or fire to be concerned about. And any interference must be necessary in a democratic society. It can't be misusing the state's power in order to effectively nullify people's rights. So let's see how civil liberties were upheld in English law down the centuries. So civil liberties, they used to be called that really, and they were adjudicated by courts. So Parliament tried to uphold these through statute, and they didn't want to take away people's rights. So there's Entick and Carrington, 1765. That's a leading case on this, saying that the government must have some sort of legal basis for what it's doing. Simply because the government does something does not automatically guarantee that that is lawful. So we can use the courts to block some unlawful action by the state. Our friend Albert Venn Dicey takes the same view. All right, so there's some sorts of protection which are known as residual or negative, but these are much castigated. It's possible that Parliament could pass a law which restricts civil liberty unduly, and do it often step by step, even if that's not their aim at the beginning. And it would just be by insidious little usurpations until we have no rights left. Or there was another case about this, so that the European Convention of Human Rights and the courts, they are the ones who supposedly uphold our rights. there was a case R. Unison and Lord Chancellor 2017, which is in the UK Supreme Court. So the United Kingdom Supreme Court, they quashed a new system of employment tribunal fees. So if you wanted to launch an action at an employment tribunal, you've been sacked or suffered constructive dismissal or something, you wanted to bring an action to an employment tribunal, fine, but the fees were going to be higher than before. The Supreme Court said you can't do that because that will prevent people having effective access to justice. The government's not going to stop employment tribunals, but they're going to make it so expensive that in practice, some people don't have access to that employment tribunal, and you can't do that. That's depriving them of their rights. So it wasn't a statute that the House of Lords was blocking, because they don't do that. Parliament is supreme. It was some particular ministerial action, new regulations. So the Human Rights Act in 1998, well, Professor Bogdanor said it's the cornerstone of the new UK constitutional order. So the Queen's Speech 1997, just after the election, it was announced. Anyway, so it came in. Sir Edward Gardner, a Conservative MP, he'd wanted to bring it in 1987, and there were various attempts by the Liberal Democrats to bring it in the 90s. So the UK government produced a white paper, Bringing Human Rights Home, in 1997, and this is what New Labour said about it when Tony Blair was at the peak of his popularity. He said it would give people in the United Kingdom opportunities to enforce their rights under the European Convention in British courts, rather than having to incur the cost and delay of taking a case to the Human Rights Commission and the court in Strasbourg. It would enhance awareness of human rights in our society. So, so UK courts can rule on convention rights. Now, much of what you find in the European Convention of Human Rights had been law in the United Kingdom for decades or even centuries. Some of it hadn't. Some of it was a novelty. So it took effect in October 2000. So what does the preamble of the Human Rights Act say? It's there to give further effect to convention rights, so to make them enforced effectively, to make these things tangible to people. Okay, so the Human Rights Act, it introduced a number of new duties for courts. So the Human Rights Act said that it is a statute, and there's parliamentary supremacy, but it so works in the same way as other statutes. Anyway. It could be repealed. So there was a case, Thoburn and Sunderland City Council 2002, about this market trade of the metric martyr using scales with pounds and ounces, not grams and kilograms, breaking EU law. There's a thing called implied repeal. New legislation can impliedly repeal something else, even that previous piece of legislation wasn't expressly repealed, as in got rid of, called back the old law. So anyway, the Human Rights Act means that UK courts, they now take into account the jurisprudence of the European Court of Human Rights. So this is what Section 2 of it says. A court or tribunal determining a question which has arisen in connection with the Convention must take into account the judgment, decision, declaration, or advisory opinion of the European Court of Human Rights. They didn't have to do that before. So anyway, so that's different from the European Court of Justice, because UK courts, because the UK was already part of the European Union at that point, had to follow the European Court of Justice's convention, the ECJ ones. The SEHR says that you must take them into account. It doesn't actually say they're binding. So the ECHR is actually less authoritative. Okay. So the ECHR and the ECJ, they're not at loggerheads. They meet, they regularly consult, and they have an amicable relationship, the judges of the two courts. So Lord Irvine, he was Lord Chancellor under Tony Blair, his former pupil master, when Tony Blair was a young barrister, and he talked about this a lot. So, and he pointed out that the UK courts are not obliged to follow the ECHR, but they will be generally guided by it. They must at least think about what the ECHR had to say on like situations. There was an important case, R. Alconbury Developments Limited and Secretary of State for the Department of Transport and the Regions, a 2003 case, went to the Appeals Court, or R, on the application of ULA and Special Adjudicator 2004, which is in the House of Lords. So Lord Bingham said there's a mirror principle. The courts know that the ECHR is not strictly binding on UK courts, but, and this is what Lord Bingham said, in the absence of some special circumstances, the court shall follow any clear and constant jurisprudence of the European Convention of Human Rights. So that's Lord Bingham, who is no longer with us. So in more recent years, the courts have become a bit more independent-minded and don't follow the ECHR as much. So anyway, for example, in R and Horncastle 2010, this appeal court case, there were 7 UK judges in the UK Supreme Court, and they all went against to the European Court of Human Rights. This was an issue about hearsay evidence, as in, I heard him say, or just one person's word against another, evidence which is not very reliable. Or there was Manchester City Council in Pinnock 2010. That case went to the UK Supreme Court. Lord Neuberger proposed that if the UK Supreme Court had to follow every single ECHR judgment, then it would become impractical. And then Lord Neuberger said it would sometimes be inappropriate, as it would destroy the ability of the court to engage in constructive dialogue with the European Court, which is of value to the development of convention law. So I do this when I finish a quotation. Convention means laws pertaining to the European Convention of Human Rights. Or another important case, R. Hallam and Secretary of State for Justice 2019, that went to the UK Supreme Court. They decided that the Supreme Court would follow its own precedent in R. Adams and Secretary of State for Justice 2010, and would disregard a more recent ruling by the European Court of Human Rights in Allen and the United Kingdom 2013. So these courts, they don't always see eye to eye. Okay, so I think that's probably enough. We'll get on to interpretive obligations on another occasion. Toodaloo.